We're delighted that you're back with us this morning and bright and bushy-eyed and interested in this topic. You heard Daniel and others yesterday talk about how the Affordable Care Act was a challenge and an opportunity, and how it was indeed a paradigm shift that will affect all of us and our children and their children for many years to come. And I think everyone in this room has certainly sees that fact of life. And in many cases, I'm really recalling what was going on here a year ago when people were just beginning to peel the layers off of the onion, so to speak, and how to implement this absolutely gigantic change in our society. And thinking about this passage of this new law and the implementation challenges is not just a paradigm shift to which we must respond, but as a call to action. There was a palpable energy in the room, in this room, a year ago, as people started beginning to think about how this could be an opportunity for states to set aside their past dysfunctional human service organizations and think about an integrated whole, and think about family wellness and not just individual stovepipe system treatments. So there came from a lot of the dialogue last year a real sense that this is the time to call upon the agencies involved in health and human services to think as one, to think as an enterprise, and not simply as a bunch of disconnected, dysfunctional individual organizations. So this opportunity and call to action has been responded to by several states in a way that will unquestionably lead to new levels of innovation and new approaches to how we build an enterprise from this collection of functional agencies. There's nothing more, and this is just maybe just an extension of what I was teasing you with yesterday, and the notion that data and its ownership has been one of the impediments to progress in this entire field, and you all know that because our tradition has been that if you enter the data about something, you own it. And in the more forward-thinking minds in this field and fields of government service in general, the new mantra is that you no longer own this data, you are a steward of this data. And there's nothing more important in changing the attitudes and culture in health and human services to think of yourselves as stewards of change in this regard. You are stewards of the data and not owners of the data. And when you get that kind of mental framework going, all kinds of things are just all of a sudden falling into place. So because of this opportunity and call to action from the Affordable Care Act, we're featuring this morning 2 states that have taken advantage of this and working under grant funding to challenge the status quo, to look at how this collection of agencies and functions and state government can be changed. You know, I think states have 2 choices in this new paradigm. One is to continue to whine about the dysfunctional state of things and say we can't change it because that's the way it's always been, or to say stop, we're going to take a whack at this and find out a way to, even if it's just tackling the narrow but incredibly complex issue of eligibility requirements in common. There are things that are going to have massive impacts that can be undertaken in this new paradigm that we've had at least 2 states, and there are more, who have undertaken this new look at who we are and what we're about. So we're going to get down to the nitty-gritty practical explanations today. And we're going to start with one of the biggest messes in the whole country, California. I'm from California, so I get to say that, but California, as you know, represents 20% of everything in the country. It's 20% of the cars, 20% of the budget, 20% of the nuts And yeah, I caught myself as one of those, but if California can get its act together and become a holistic provider of service across the entire state, I would have to tell you that almost any state could do it. So with that, I'm going to provoke that challenge to Shell, who's going to lead this off and describe what the state has attempted to do under their funding for this innovative new program. Shell?
Okay, so what you're about to see is, and I'm going to talk a little bit about our grant project, but part of our grant project involves a couple of symposia, very much like this one, although our environment wasn't as nice as this. But you're about to see about a 5-minute compilation of the kinds of things that we did at our first symposium.
Ever since there's been information technology, we've been building silos.
I want us to recognize that this is not a simple thing. If it was simple, we would have solved it by now.
It's quite frequent that we have multiple departments within our agency that collect the same data in 15 different systems.
I was amazed maybe a year ago to find that we still exchange data on microfiche. I didn't even know you could find a microfiche reader anymore.
It's not about how we move the data anymore. It's about how we get that data to where it needs to be and then what we do with it when we receive it.
How can we rationally protect the legitimate privacy interests of the children and the families that we deal with, at the same time get us the information we need so that their lives are made better and not worse?
Whenever you get a confidentiality question, the easiest and safest answer to give on information sharing questions is always no. But we end up with situations where people who have to make decisions don't have the necessary information they need in making those decisions.
The legislature of California has said that judges, believe it or not, judges have to approve the administration of psychotropic medication for children who have been removed from their family's care. That is an extremely heavy burden.
Every time I hear our judicial partners speak about this and the fact that they're being asked to make decisions essentially as a parent without the information that a normal parent would have when they walk in the door, it gives me that sense of urgency.
How do we keep everybody on the same page when essentially what we have is a system that's operating with the movement of paper?
One of the key things is to ensure that we have all of the right people at the table to be having the discussions, to ensure we have the champions to move innovation forward.
It's really critical that we are all having this same conversation at the same time.
Part of the way to get to yes was leadership in the agency.
An advantage I think government brings as being a convener, not just a policymaker and a funder and a provider, but perhaps our most powerful role as a convener.
But whether we're talking data sharing, information sharing, interoperability, or actual integration, at the bottom of it, I think we start by saying that our intention is to develop a culture of communication.
We are moving from a culture of treating illness to a culture of creating wellness and prevention. And who better to demonstrate that than our population of foster children?
What we should expect when we embark on these types of change efforts is that care, the quality of care will improve, patient satisfaction will get better, and costs should go down.
I think folks today got a peek at what is possible if you're able to share information and better serve your constituents.
We have the technology to do it. The will seems to be here from the leadership on down, and now is really the time for us to move on interoperability and share data across systems.
Everyone is anxious, I think, to sort of seize this moment and take advantage of this opportunity to create interoperability.
The fact that we're talking about how to make it happen and we're coming from the concept of yes, not no,
is huge.
Get involved, get your voice in, talk about the population you serve, because I've learned a lot from, sitting with the folks from legal, sitting from folks from healthcare, sitting from folks from the courts, that you're like, oh, I didn't see it through that lens.
Actually, at this point, I'm really hopeful that something good is going to happen, and that something good is going to happen soon. I think we're there. I think we're really close. We're on the cusp of moving to the point that we all want to be in, and I'm excited for that.
We need each other to be the heroes. It's impossible in our story for any one of us to be a hero by ourselves.
The work that you are undertaking and the opportunities that you have, I think will influence the rest of the country.
We heard all the compelling reasons, and I think none of us would disagree that this isn't the right thing to do.
It's going to be meaningful and purposeful work, so we can make a huge difference. It will happen, but it's going to take a lot of work on your part.
I feel a little bit like a movie star. Glad I didn't wear that sweater again. So I want to just tell, just a little bit, obviously we did a conference. We're going to do another one, but, and I'll talk a little bit more about that later, but let me just give you a little overview about what's going on in California, and maybe a little bit of history, just a tiny bit of history about how we got here. So Paul, thank you very much for the introduction, did say last year that we sort of started the Affordable Care Act journey, and we were at this conference last year. We were just kind of given a hint of a grant opportunity that would drop shortly from Administration for Children and Families. And I don't know how there's nobody else in the room, I think, that was at that conference and heard that and then applied, right? So, but you guys weren't in the room, right? Yeah, so Illinois is obviously another granted state, but we just kind of, it was sort of waved in front of us, and then it was kind of gone. So, and then the grant opportunity dropped, and we started scurrying around, and I thought that, this type of a model had been so impactful in moving the conversation forward for the folks in this room. I thought, we need to do something like this in California. We need to have this kind of conversation in California, and I think we need to have 2 at least, or maybe 10. Because as you heard from the folks in the video there, this is a long-term kind of a change, and it can't be a one and done and think that we're going to get what we want. I mean, this is the 8th annual conference that stewards have been putting on, and I thought, well, geez, we're going to have to do a lot of those, but if with the grant money that we get, let's do at least 2. So we have to, out of our grant, we have to fashion a vision that everybody in California buys into, because at this point in time, we don't really have one. We have the good intentions of Larry and Mike here, and maybe myself and Adam and Barbara, but the good intentions don't buy you very much. We need to have a vision. So the first thing that we need to produce is some sort of a vision of where we're going. And because I'm from the technology side, my tendency is to sort of think about how can I leverage that vision for what we need in the state towards interoperability. And some of the things that we need are standards. So the federal government through the Affordable Care Act has said, if you're going to use our money, you're going to do our standards. So I think that's a convenient point of departure, and we can just kind of adopt those standards wholesale. So our vision includes the Medicaid Information Technology Architecture, and it includes the National Human Services Information Architecture, and it also includes the National Information Exchange Model. So we're just going to elect not to spend gobs of money to have someone develop an architecture for us. We'll just use that. And then, the overlying objective there is to improve service delivery. So I wouldn't be too surprised if, after our second symposium from our grant, that we come out with a vision that says something like that. but we're going to, part of the grant work involves people building the vision. So, those are just mere guidelines. So we have some systems that we're working on currently that present some opportunity to operationalize parts of that vision. And we're kind of, if you're getting a sense that it's a little disjointed, I think you're right. It's, we're a little bit out in front of the actual planning and the actual vision statement. We're running kind of a little bit of ahead and saying, come on, we're on our way. Come with us. So we have some systems that are about to start up, new builds or refreshes or however you want to characterize that. We have a new child welfare services case management system about to be built, so that's a big opportunity to leverage. We have, of course, the Affordable Care Act that we are building a new system in California to operationalize that. I had the opportunity, I'll call it an opportunity, to run that project for about 5 weeks while we looked for a new project director. And my sense from what we're doing there and how we're doing it is that we'll actually make it. It may not be pretty, but it will be functional on January 1 when it needs to be. We will also refresh our Medi-Cal eligibility database system, the MED system, in the next couple of years, and we'll also build a new management information system and decision support system for Medi-Cal, which is our version of Medicaid. And we are also in the process of a new Medicaid management information system, all of which sound like the same system, but they all serve somewhat different purposes. And now, because they are new systems, they will be built with a service-oriented architecture, and that means that we will be able to finally have some flexibility so that when one part of that system needs to be updated, we don't have to throw the whole baby out with the bathwater. We can just get new bathwater. So that's good news. And then in this notion of interoperability and horizontal integration, the state has recently, through the Department of Social Services, appointed an assistant director for horizontal integration. That's Adam Dondro sitting over there. Wave your hand, Adam. And basically what I would like is to see every state department in California appoint an Adam so that we can have these champions across Health and Human Services Agency having this conversation on a regular basis. We also hired, let's say, a coordinator to help coordinate with the Health Benefits Exchange from the eligibility and enrollment retention system, somebody to coordinate all of that possibility, all of that opportunity with the rest of Health and Human Services Agency, because actually the Health Benefits Exchange in California sits outside of the Health and Human Services Agency. So we felt like we needed to have a very good tie to make sure that what they're doing is reflected in what we're doing and vice versa. And let's see. So we get, we have some work group efforts going on. The grant is one of them. And before I talk a little bit more about the grant, let me just also say that Larry is going to talk a little bit about the legal environment there in Health and Human Services. But the work group that Larry has been instrumental in getting our chief counsel at Health and Human Services Agency to spearhead and helping them see that yes is a good place to be is instrumental in continuing that conversation in the legal community. So I'm anxious to hear what Larry's going to share. And then on our grant, I said I would talk a little bit more about that. So what our grant will do is we'll hold 2 symposium. Oh boy, already? Okay, so we'll hold 2 symposia, and we're building on, you heard a lot of sentiment there expressed about foster kids. What we tried to do is leverage anything that we could when we put together the grant. And one of the things, if you were here last year, you heard Dr. Lynette Scott talk about the audacious goal for health information exchange. And that audacious goal is the foster child use case, and doing whatever we can to improve how we raise foster kids in California. So we're using that use case to demonstrate a proof of concept on psychotropic drugs, and I think maybe Judge Nash will talk a little bit about what is needed there. And most of all, we will come out with hopefully at least at a high level, a governance model, because we can't even start this conversation around sharing or have this conversation around sharing until we know what the rules are. How do we do that? And I think that was the intent of the ACF last year in putting together the grant opportunity to begin with, is to help states prepare for sharing through governance. And then we'll also come out with a roadmap of how to get there. So the good news is that we started with the IT piece, and it might not sound like good news because it's not the foster kid piece, but the IT piece is good news because we all speak the same language, and we can actually get to some places that help the program side come along. And so the biggest challenge that we have, I think everybody has heard it loud and clear yesterday, and maybe a little bit in the video, is we don't have a culture of sharing in California, and I don't think a lot of people do have a culture of sharing. It's a new way of thinking. It's it's just a different. When you think about the American culture in general, it's an entrepreneurial culture. It's a build it and you own it kind of culture. And now we're basically saying, we don't want you to do that. We want you to build it and share it, and that's going to be hard. So that's what I had. Do I have like a minute left? Yeah. Okay. Let's see, who's next? Is that Judge Nash?
Good morning, everybody. I'm not going to talk about this idea of information sharing and this culture of no, because I could talk for hours about that, about the problems that we've had. And unlike Shell, I'm not from the technology side, but I'm smart enough to know that it can help. I'm just a judge, and usually when I talk to my colleagues around the country, I tell them that I'm kind of the feel-good judge, because when I tell them about the issues that we have in Los Angeles, they're going to feel good about the problems they have in their own jurisdiction. I'm the presiding judge, for those of you I haven't talked to before, I'm the presiding judge of the Juvenile Court in Los Angeles. In Los Angeles, we have 20 full-time dependency courts, those are the courts on the child welfare side, and 22 delinquency courts on the juvenile justice side. It's the largest juvenile court system in the United States. We deal every year with upwards of 50,000 children and their families. And certainly from the judicial perspective, it's important that to know that we need more, we need more and accurate information so that we can make the appropriate decisions to hopefully achieve better outcomes for the children and families that we have to work with. The issue that I'm going to talk about for just a couple of minutes here today is a very important one to lots of folks, and certainly it's one that it's been important to me and the folks in our jurisdiction for many years, and it relates to the use and administration of psychotropic medication on children in our systems. In Los Angeles, in our juvenile court system, at any given time, we have 3,000 to 5,000 children who are receiving, children and youth who are being administered psychotropic medications. And in California, unlike the majority, probably the overwhelming majority of jurisdictions throughout the United States, the court has to approve the use and administration of psychotropic medication on the children before us who are in out-of-home care. And that means in Los Angeles, we receive upwards of 10,000 requests to administer psychotropic medication to our kids every year. It's an important issue. It's an important issue for lots of reasons. Number one, There's lots of data to show that foster kids, kids in out-of-home care within our systems receive psychotropic medications at a higher rate than other kids. It's also important to note that the FDA hasn't even approved most of these medications for the use of children, even though they're used commonly in practice for treatment purposes. So the message out of that is we need to be very cautious in our use of these medications. And the other piece to know is that within the framework of our child welfare system and our juvenile justice systems in this country, the court has a very significant oversight role over those systems, and that oversight extends to every aspect of the lives of the children before us, and that includes psychotropic medications, regardless of whether or not a judge comes from a jurisdiction that is, like California, that requires the judges to approve the use of medication. We still need to know when and how it's used and whether it's working and so forth. So the kind of issues that we deal with on a daily basis with respect to psychotropic meds in our kids is the approval process. Who's approving it? Why is it being approved? How's it being used? And so forth. How's it working? That is a monitoring process. And we know that within the framework of our systems, kids are moving all the time. It's one of the banes of our existence. And, you know, a question that not too many places have dealt with that we've begun to deal with in Los Angeles is how do we make sure that we maintain the medication regimen when children move as frequently as they do, because an interruption in that medication regimen can have a very serious negative effect on the children. And then every year throughout the United States, we have thousands of young people who are transitioning out of our system back into our communities. We used to refer to them as emancipating youth, and many of those youth have been taking medications for years within the framework of our system. And what are we doing to train and educate those kids and prepare them to make medication decisions for themselves within the framework, and once they've reached the age of majority and have to take care of themselves? And I've always wondered, and I say this all the time, is that there are many, many studies that show that youth that transition out of our system because of their age have basically negative outcomes. And the question I've always wondered is how many of those kids' negative outcomes is impacted by their use or misuse of the medication regimen that they were on because they don't know what they're doing, or they don't know how to access the medication. They don't have a continuing relationship with a doctor. And then, of course, another issue that I know that in Illinois they've begun to deal with, I think, in a positive way. We're working on this in Los Angeles as well, is, you know, what about this idea that so many of our kids are receiving multiple medications? And is that good for our kids? And do we need to monitor those kids much more carefully than we do? So it's another issue that we're working with. And then how do we prepare caregivers for children in out-of-home care, and how do we prepare parents when we return their kids to them to make sure that they're able and willing to manage the psychotropic medication regimen for their children. And the thing about this process, certainly in Los Angeles and elsewhere, is that the whole process depends on the flow of paper from the physician to the agencies to the court to the players in the court process, and ultimately to the caregivers. And it's a wonder that that there isn't, and I'm sure there is, actually, it's not a wonder, I'm sure there's a lot that's lost in the transition. So this is why utilizing technology to maintain an accurate and consistent database on this issue is so important. So this proof of concept that Shell talked about, this grant to the California Health and Human Services Agency from Administration of Children and Families, is very important because it will help us focus focus on creating an electronic data process for the use of the medications in kids in foster care. And as I said, it's an important issue. It's an important issue to members of Congress, many of whom I've talked with. It's an important issue for ACF, and it's an important issue for the National Council of Juvenile and Family Court Judges, a large 2,000-member organization of which I'm the current president. We have created a committee that is working on developing standards for all judges to use throughout the United States as to how we should deal with issues related to psychotropic medication, and our standards are probably within a month or two of being publicized throughout the United States. So I'm excited about this process because of its focus on this very crucial issue for us. And I'm excited about the fact that ultimately it can have a greater impact on our ability to share other kinds of information that is so important for us to make these important decisions that we have to make on a daily basis.
Good morning. I'm Larry Bolton. I'm counsel to the California Health and Human Services Agency Interoperability Project, and yes, that means I am a lawyer. The comments made yesterday about lawyers included terms like roadblock, delay, impossible. I was having breakfast with Shell this morning, and she heard someone with a variation on the Shakespeare quote, well, first let's shoot all the lawyers. I don't think Shakespeare said, he just said kill, but that's certainly one of the options. I think there's other things. More typically in government agencies, when you're dealing with lawyers on confidentiality questions, people have learned to just avoid dealing with the lawyers or put it off till the end. And I think that's a problematic approach, because when attorneys are brought in at the end, they have a tendency to do what's happened with the HHS toolkit on information sharing. They've been reviewing it for the last couple of years. I think the deputy mayor in New York said, did she say it was 2 years that things got delayed by her internal attorneys, and then they went to the mayor's attorneys, and God knows how long they spent there. But I think there's a third option, and that is to try to educate your lawyers and get them involved earlier on in the process, because a good lawyer can also be a facilitator and try to help you get to the answer that you need to get to. We, at our symposium, we called it trying to help get to yes. It's frustrating because the gut reaction of lawyers generally, and the approach you learn in law school, is to protect your employer from liability. And as I said on the tape shown earlier, the easiest answer to give is always no. But that's not the answer that is oftentimes in the best interests of the clients, of the children in care, or good public policy. I think that we've had a tendency over the years to build, we've referred to them repeatedly as silos. I said in California, when we did our last child welfare case management system 20-some years ago, we didn't just build a silo, we built a fortress. We didn't want anybody to, under any circumstances, be able to get into our computer system if they didn't work for a child welfare agency. The new approach we're going to be taking for the future is to design a system that will have access by other people, obviously with the necessary privacy protections built in. And that's going to be the hard part of all of this. I think technologically a lot of these things are doable. The problem is it's not black and white. There's 100 shades of gray in terms of who should have access to what. If we're going to allow outside folks to have access to parts of our system, it's going to be so important that we build in the necessary protections to make sure that the information isn't misused. An example, years ago when AIDS first became an issue, and we had a lot of children being born to HIV positive moms, where the children were often, because of the mother's incapacity or death, the children ended up in foster care. California and New York, for example, took two very different approaches to how to handle that. In New York, the determination was made that you wouldn't inform the foster parents that the child was HIV positive because of confidentiality issues. In California, we took the opposite approach. We decided we had to tell the foster parent, but that information was required by the state to be kept confidential by the foster parent. When the children got older and were in school, you can keep the kid out of school and send in the note saying Johnny was out because he had the measles, but you couldn't say Johnny was out because he was having his HIV treatments. It's going to be important as we build these new systems in the future that when we share information, we do so balancing the privacy rights with the importance for sharing the information. In California, to use an example in the foster care system, there's two categories of information where foster parents often have very little information on the kids they're being asked to care for. In many areas, they weren't getting educational records because of concern about FERPA violations. They were also not getting health information. People were concerned about HIPAA and other confidentiality laws. And when you look at the relationship between a foster parent and a child that's in long-term placement, you have to realize that applying HIPAA or FERPA in a particularly conservative manner is not in the best interest of the child. When you've got a 6-year-old kid that's sick and the foster parents take them to the doctor, the foster parents pointing out the rash, discussing the symptoms, and then the doctor's giving them a diagnosis and a prescription. We have advocates that saying, well, that information shouldn't really be released without the child's attorney consent or whatever, if the child's under 12. Reality, if you're a foster parent and you're caring for the kid, you need that information to be able to care for the child. Same thing with when you're in long-term care, the foster parents are taking them to school, picking them up from school, and yet we have school districts that are saying that the foster care system shouldn't have access to the educational information on the child because of FERPA violations. Again, if I were a foster parent and being asked to care for a kid where I wasn't getting the health information or the education information I would say, take the kid back. This can't work. You can't expect people to function as de facto parents on a day-to-day basis if we don't share with them the necessary information they need to adequately care for and supervise the child. In California, I first became aware of the importance of this. I didn't know the word interoperability until about 2 years ago when I met Daniel and became aware of stewards. But I became aware of the importance of information sharing when I was appointed, along with Judge Nash and some other folks, to our Supreme Court's Blue Ribbon Commission on Children in Foster Care. And at held meetings somewhat like this, and at one of the lunches, I was talking to a couple of the judges, as I said, Judge Nash, Judge Stout from California was on it, and realized that the courts were building a case management system for child welfare at the same time that we were going to be, we thought, developing our new child welfare system for the social workers. We assumed they were being done jointly, and we found out subsequently that they were being developed in complete vacuum without talking to each other. And the leadership of the judiciary and the social services agency got together and set up a process whereby we had county workers and the court workers from the welfare departments, child welfare, and the courts working together, and decided that when and if we ever get our new court management system and when we procure our new state child welfare system, they will be done jointly, and there will be access back and forth so that we have an ability to share information timely and have accurate information, so that's still, 3, 4, 5 years away before it's going to be finally up and running. But at least now, as we develop the RFP, we're looking at using terms like interoperability. Our Blue Ribbon Commission voted out a policy statement just a month ago. I think this is going now to our state judicial council, which is the administrative arm of our state Supreme Court, and it specifically encourages interoperability and information sharing. And I don't know of any court in the country that's adopted a policy even using that term. We also have a Child Welfare Council in California, co-chaired by our State Health and Human Services Agency Secretary and one of the appellate court justices, so appointed by the Chief Justice. They also adopted a similar policy encouraging information sharing. So I think at the top level, there is a realization that this is important. what I think is incumbent upon all of you, there are not a lot of lawyers here. I think whether it's a lack of interest or they were just smart enough to try to stay away, I think it's important. Yes, that was a good. I think it's important that you not only involve them early, but educate them. Get them. They need to get out into the field. They need to They need to go into juvenile court and see what's happening. They need to interact with foster parents, and not write their legal opinions in Washington or Sacramento and then impose them on the folks in the field. I think the earlier you involve them, the better. Again, as long as you get them to understand that it's not really in anybody's interest to elevate privacy rights above the best interests of the clients and the folks in the programs. I think that we owe it to the kids to make sure that, yes, we certainly want to maintain their privacy, but we also want to maintain their health and safety and inject a bit of common sense. That's about it, time-wise. So, and then I think we've allowed time for questions from the.
Thank you all very much. Are there questions? They were all that eloquent.
So one of the things we were talking about earlier was, Larry, the challenge of the challenge of bringing attorneys into the conversation earlier, as you suggest, is that now you've got the attorneys in the conversation earlier.
That cuts both ways. You're right.
Yeah, right. So it cuts both ways, but it might be interesting to just discuss for a little bit, because you're right. On one end, if you only bring people, nobody likes to be brought into a fait accompli, a decision, approve it or not.
Right.
That doesn't work well in any behavior, really. But on the other hand, there is risks to, sort of.
It's important, I think, that you not let the attorneys stop the process in the very beginning. When the Child Welfare Council developed their policy on supporting information sharing, I took it to our agency chief counsel's meeting. We have 14 departments and offices in our agency, and when I presented it, I was met with 13 people that were just shaking their heads because their general approach is, what are you talking about sharing information? We've built our silos. We like our silos. We don't want to change them. I think this is why it's important that we try to get the attorneys educated as to why we need to share information and the value of it. I think it's important that management let attorneys know that they're not the ultimate decision makers. They can, it's their job to give pros and cons regarding potential liability, et cetera. But if you make avoiding liability the only concern for the agency, you're not going to be necessarily doing what's in the best interests of the clients.
Well, I come from the courts, and we don't do anything without attorneys in the courts. So every collaborative that I am associated with is heavily populated by attorneys. And I think the important thing is, and it really doesn't matter if you're dealing with attorneys or others, is that once you have a group that's there to talk about an issue, that the first thing you do is reach some consensus on what the problem is. And if you can do that, then you stand a good chance of ultimately reaching some consensus on how to solve that problem. In Los Angeles, I've been in a leadership position for a long time. We've had a lot of collaboratives, and we know that once we settle on what the nature of the problem is in the collaborative, we're not leaving the room until we have some sort of consensus on how to fix that problem.
I think it's also important that attorneys be viewed as advice givers rather than ultimate decision makers. I had a county child welfare director call me saying, when I found out they had put out a policy that foster children in that county would no longer be allowed to get library cards because their county council had opined that there was no appropriation for fines and we couldn't hold the foster parent liable, and therefore the solution was to not let any of the children in foster care check out library books. And I said, this sounds to me like a occasion where you might want to thank your lawyer for their advice and then decide what made sense. And if there's a kid that has a big find, take up a collection, but don't prohibit children from getting library cards. I can't think of anything, well, there are worse things you could do, but that's right up there. So,
I have a question over here.
Well, just a comment. There is a field of legal informatics. I just wonder if they might be some natural allies. What is striking actually is a center at Stanford, which is in California, I understand, of the Center for Legal Informatics. So it just is a thought that comes to mind.
That's interesting. Okay, thank you.
Good morning. Thank you for your presentations. I am not a judge, but I'm a systems engineer. And for the past 2-3 years that I've been associated with Daniel in various ways, we've been admiring the problem in meaningful ways. But from your perspective, if in your most optimistic view of the world, if all the systems engineers could get together and devise a system for you that you would be able to use day in, day out, what would be the characteristics of such a system? What would you guys like to see as the judiciary side of the users of such a system? Again, think of the most optimistic view of the world. How would that system should be put together for you guys to be able to say, aha, this is the kind of systems I want to have?
Judge?
How much time do we have here? I mean, there is so much information that we receive on a daily basis. Our judges in our juvenile courts are just making dozens and dozens of decisions relating to children and families every day. And so, at a minimum, I'd want a system that at least does one thing, that incorporates all of the connections that those children and those families have had with court systems, so that we know what's been done before, we know what some of the problems were before, and that and we're not doing something that's inconsistent that's been done somewhere else. We're not repeating maybe some of the same mistakes that were done elsewhere. And we often are in the dark about that. And as you know, people move from jurisdiction to jurisdiction, and we don't know. There isn't always information about what happened in that previous jurisdiction. Hey, in Los Angeles, we have families that are not only involved with our child welfare system, we have these same families are involved in our criminal justice system. These same families are often involved in our family court system. They're often involved in our probate system, and yet we have trouble getting information from those other systems as to what's going on there. And at a minimum, we have to have that kind of information to utilize when we work with a family.
And how about medical information?
I'm sorry?
Medical information?
Oh, of course. Now you're talking about personal information that relates to the family as well. To the extent that information could be available, yes, it's extremely helpful to us. But once again, there are so many different systems that interface with so many of our families, and they interface with them at the same time, and there's not generally a way of knowing that.
In other words, there has to be one system that records the complete history of all the transactions between health, human services, and the justice system, and is made available on the basis of the need to know to make decisions about that child.
Well, I'm thinking more in line of systems of systems.
Yes, well, this is a topic we could talk about for hours, and probably will, but now we don't have the time to do it, and we need to move on with the next presentation. I'll take one more question, John.
So I'm John Teeter. I'm currently with KPMG, but So I'm currently with KPMG, but formerly I was the chief architect, deputy CIO, and CIO of the U.S. Department of Health and Human Services. And I'm just going to give you some of my observations. It's about the data. It's not necessarily about the systems. So the data that surrounds an individual is really what will allow you to modify the functionality as you need to over time. Because rules and regulations will change, legislation will change, and the modular approach to managing all of that is really what the target is. But what I'd like to suggest is that groups like this, in my experience, have not leveraged their influence to cause the federal programs to modify their behaviors. And I'm going to suggest that maybe that is a good opportunity to start with saying yes, getting to change, and because the federal programs many times drive behaviors out in the state governments and within the state programs. And I think that that's really the starting point, is to coalesce around the influence that you all really have and affect the change that is necessary in those federal programs.
Very good advice, John. And with that, I think we're going to need to move on to the next presentation. I want to thank the California contingent.